Massive news in support of gun rights and the Second Amendment out of the state of Oregon. Breaking news just occurred hours ago. The Supreme Court of the state of Oregon just denied the state of Oregon's attempt to start to implement their new crazy gun control laws, including bans on so-called large capacity magazines and so on and so on. The state Supreme Court just denied the state's request to implement that law. I'll break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're trying to get to 100,000 subscribers to help us with the social media algorithm. All right, folks, this is huge news. I'm going to do a series of videos on this, but I'm going to start with this one right here, right now, dealing with a decision by the Supreme Court, the state Supreme Court, not a federal court, the state Supreme Court of Oregon that denied a writ of mandamus request by the state of Oregon's government. You may recall that in November, Oregon voters passed by literally a size of a nail, like less than 1%, I believe, was the margin of this vote, an onerous, draconian gun control law by popular referendum, which is allowed under the state law in the state of Oregon. Now, among other things this draconian gun control law did is it essentially outlawed magazines that could hold more than 10 rounds, labeling them a propaganda term of large capacity magazine, when in reality, as you know, magazines that hold more than 10 rounds, both for pistols and for rifles, are indeed standard capacity magazines that everybody basically owns all across America. So anyway, the other thing they did is they wanted to implement this sort of crazy kind of permit scheme in terms of how you bought guns, acquired guns, and whatnot. We won't get into that so much, and you'll see why, because it's not going anywhere. But basically, the Oregon voters voted in these gun control laws in November. In December, on December 15th, a massive victory, which I'll put a link to down below. A trial judge, Judge Rashio, I hope I pronounced that right, Judge Rashio. I don't want to offend anyone by mistake. But Judge Rashio, who was the trial court out there, heard a preliminary injunction hearing and decided indeed that under the state, and this is key, the state of Oregon's Constitution, not the Second Amendment, not the right and keep and bear arms under the federal Constitution, the Second Amendment, but under Oregon's state constitution, this gun control law violated the state's right to keep and bear arms provision, which I believe is Section 27 of Article 1. But it's in the opinion that I put down below. Now, the judge did a fantastic job, as I see it in some of his findings of fact after hearing testimony and looking at affidavits and making decisions about so-called large capacity magazines. Now, what Judge Rashio decided was that it's clear that this referendum that banned so-called large capacity magazines was unconstitutional under the state of Oregon's Constitution. And because of that, he specifically said, and remember, I've taught you this before, under the doctrine of constitutional avoidance, if you can decide a case without having to deal with a constitution or without having to deal with the federal constitution, the general rule under the doctrine of constitutional avoidance is to do so. And that's exactly what Judge Rashio did here, where he said that I am ruling against the state of Oregon, finding that their gun control law was unconstitutional under the state's constitutional right to keep and bear arms, and therefore I am not going to address or consider the Second Amendment's right to keep and bear arms under the federal Constitution because I don't need to. And again, under the rule of constitutional avoidance, if you don't need to go reach out to the Second Amendment of the Constitution and you can resolve it without doing so, the general rule is you should do so. And that's exactly what the Oregon judge did here very wisely. But his decision was very powerful. And the reason why I get into this is because the state Supreme Court of Oregon came out late yesterday, and said that Judge Rashio's decision would be upheld for the moment, that the state's request to mandamus, which is basically an emergency request to stop the decision from going into effect of the lower trial court, that writ of mandamus would be denied. And this is what the state of Oregon Supreme Court said in favor of the lower court victory for the gun rights plaintiffs in the state of Oregon. Here is what they wrote. They said, State of Oregon, Supreme Court, the petition by the state of Oregon for a writ of mandamus is denied. Without prejudice, which means they can come back, that's not unusual, without prejudice, and the motion for a stay is dismissed as moot. So basically, the state Supreme Court said in a per curiam decision, which means the whole court decided this, that they're not going to mess with the lower court decision, and the lower court decision, as you know, enjoined, stopped, declared the Oregon gun control referendum to be likely unconstitutional in violation of the right to keep and bear arms under the state constitution, and therefore it cannot go into effect. That's what the trial court said, and the state Supreme Court of Oregon just says, we're not going to get to the merits right here, right now, but we're not going to do anything extraordinary or unusual. We're going to let it play out. We are not going to enjoin the lower court decision. We're leaving it to play itself out. As a consequence, the injunction that stops the crazy gun control law from going into effect in Oregon has been stopped for the moment and will likely remain stopped far into the foreseeable future. I'm guessing many, many, many months, if not longer. Okay, so that's huge news, very big news in favor of us, even though it's not specific to the Second Amendment, the reality, it really is. And we're going to do a series of videos why this is huge for the Second Amendment in just one moment. Now, just to remind all you, the Oregon trial court, which right now has enjoined, which means stopped, the Oregon law dealing with bans on so-called large capacity magazines and this permit scheme for gun possession and whatnot from going into effect. I'll talk about those separately. First of all, let me just quickly deal with the permit scheme. Oregon has this proposal that was passed by referendum that says you have to have a permit before you can do certain things with firearms, but the state says we're not prepared to go forward because we don't have a system in place. We haven't got the computers up and running. We don't have the staff. Basically, we're just not ready to implement the system that was enacted by referendum in November 2022. So the court said, look, I'm not going to rule specifically on that because it's a moot point because you don't have your stuff together yet, state of Oregon. So here's what we're going to do. That part of the law is not going to go into effect. It's enjoined. And if and when the state of Oregon gets their permitting scheme set up systematically, they are then allowed to come back and they have to tell the court, hey, we're ready to go into effect. At that point, and this is very fascinating, the judge is very smart. The trial court judge says, at that point, I'm going to then have a preliminary injunction hearing as to whether or not the system that you've set up is constitutional under the Oregon State constitutional provision of Section 27. So basically, the question of the permitting scheme in Oregon is on hold. So that's great news for gun owners because it's not in place. And when it does get set in place, there will be an opportunity to have a hearing in front of the trial court judge as to whether or not it's constitutional. So that is being put off to another day, but in a favorable way. But the reason why I think that's so important is that unlike places like New York and California, where even though they don't have their act together with the permitting, meaning they're saying, oh, we're backlogged years and years and years. I think that's probably unconstitutional, but that's for a different video. But they're saying we're backlogged years and years and years. The proper remedy, in my opinion, in places like California and New York, when licensing divisions with police departments say, we can't get to your license, we can't process your license for 2 years. To me, the proper judicial remedy in that situation is for you should be allowed to carry your gun without a permit. And when they finally run the permit, if it turns out you're not allowed to have the gun, they call you up and say, actually, it turns out you're not eligible. Then they take your right to keep and bear arms away. Because the way that's working in New York and California now is the delay on the part of the government is hurting the constitutional rights of the Americans who want to carry guns and the excuse that government's inadequate. But in contrast, what Oregon did, this trial court says, we're not going to hurt gun owners because the state of Oregon can't get their act together. That is a far cry. That's what's happening. So I'm hearing in places like California and New York, this is because the states can't get their act together and process these permitting, the license to carry permits quickly enough. The people paying the price are the people that want to carry guns and cannot. But Oregon did it right in this case. We'll see what happens in New York and California. That may be an issue that comes up down the pike. But for now, we'll see what happens. So anyway, that's the first issue. But the other thing that Judge Ruscio decided, huge decision, fantastic decision, with one caveat, is that he clearly said that so-called large capacity magazines are actually standard capacity magazines. So he made that conclusion. He said that these have been around forever, which is basically true. Certainly at least, well, we can debate about when, but I mean, as you know, the Girandoni air rifle that Lewis and Clark brought with them back in, I think, 1809, 1808, when they went across the West on behalf of President Thomas Jefferson after Jefferson purchased the Louisiana territories from Napoleon Bonaparte to fund his wars against Brits. Thomas Jefferson as president set Lewis and Clark out, and one of the weapons that they brought with them was the Girandoni air rifle, which held somewhere between 20 and 24 rounds. That sounds like that's more than 10 rounds in the founding period right then and there. But anyway, beyond that, what the judge here said in Oregon at the trial level, he says, obviously, these are standard capacity magazines. He then said that and this is why it's so important to understand, this was a state constitutional decision. He said two critical things that touch fingers with Second Amendment issues at the federal Constitution. What he says is, number one, that the Oregon Constitution has to provide at least as much protection under state constitutional rights when it comes to the right to keep and bear arms as does the federal. In other words, the state constitution has to protect at least what the Second Amendment protects in terms of rights, and it is allowed to go beyond that under the state constitution, but it cannot fall below the Second Amendment right. So the way to think about it here is that the Second Amendment's right to keep and bear arms sets a floor below which state constitutional rights can never fall when it comes to the right and keep and bear arms, but state constitutional rights can go above the federal constitution. So you can expand constitutional rights at the state level beyond the federal constitution, but you can't drop it below the federal constitution. And Judge Ruscio made an excellent point making that observation. But the other critical thing is here, under the state of Oregon's constitutional precedents by the Oregon Supreme Court over the years, they have adopted essentially a tiers of scrutiny model of balancing the interest of gun owners against the interest of the government in terms of public safety. I've taught you here that tiers of scrutiny is very, very, very bad because it gives opportunities for judges to simply weigh your rights away and say, well, you're just one person with one gun, with one magazine that holds more than 10 rounds. I've got the entire public interest of the state of Oregon on the other side kind of stuff. So it's very easy for government judges to rule in favor of the government, saying, oh, well, they've identified a compelling state interest, so who cares if one guy in some state can't have a gun with more than 10 rounds. So you see how easy it is to balance away. But the good news here, even though the trial judge here in Oregon applied this balancing test of essentially strict scrutiny or some form of that, he says, there's an interest here in protecting Oregon voters and Oregon residents from so-called mass shootings, but the reality is the massive burden of violating their clear rights, as he saw it under the Oregon State Constitution, right to keep and bear arms, that massive violation, which is irreparable harm on its face, when balanced against the rare event of a mass shooting with some sort of magazine that holds more than 10 rounds, he balanced it out and says that there's no way that the right of Oregon gun owners can be outweighed by this sort of speculative, theoretical, conceptual notion that some mass shooter is going to follow the law and not have magazines that hold more than 10 rounds and so on and so on. And the judge said, no way, no how, I'm going to rule in favor of the gun owners. And here's the key language that the judge issued in the trial court that the Oregon Supreme Court refused to touch, refused to interfere with or override. Here's the key language from the trial court. I think you're going to really like it when I read it to you. This is what Judge Ruscio said in his trial court ruling that the Oregon Supreme Court effectively said they're not going to interfere with right now. This is what the trial court in Oregon said. Very powerful, very good, in favor of the Second Amendment, even though it's under the Oregon State Constitution. He writes, in his opinion, quote, the statutory scheme, which is the Oregon referendum gun control that just got enacted in November, the statutory scheme is very burdensome on lawful firearm owners who possess large capacity magazines legally now. Clear from the preliminary record, magazines capable of holding more than 10 rounds come standard with many popular firearms and firearm platforms on the market today and are possessed by law-abiding citizens for lawful purposes. The measure criminalizing currently lawful conduct, creating presumed criminals out of every 5 Oregon voters or Oregon residents. In other words, under Oregon State Supreme Court law, in other words, under Christian and Oregon Supreme Court decision, The regulations are unduly burdensome on currently lawful conduct and are without a public safety promotion. The court is clearly persuaded that plaintiffs, the Second Amendment plaintiffs, have a likelihood of success of showing that the new gun control referendum is unconstitutional under Article 1, Section 27, which is the Oregon State right to keep and bear arms statute, or provision, I said, constitutional provision. The court will not turn to the federal constitution as a consequence. So here you go is the key language. So again, major win in Oregon. The Oregon Supreme Court upholding that is a huge victory for the Second Amendment, even though it was based on the Oregon Constitution. I just want to make a note that here's what I think is going to happen. You may also remember that there are, I believe, 3, 4, or 5 cases pending in front of a federal judge out there. The federal judge, as I recall, denied the plaintiffs, the Second Amendment plaintiffs, a TRO request, which meant that under the federal court decision, the Oregon referendum could go into effect, but it doesn't matter at all because of this decision by the Oregon Supreme Court and the Oregon lower court that the Oregon law may not go into effect yet. It's been enjoined. What I think this means is that the federal cases out there, I don't know their exact procedural posture, but the federal cases out there actually, when it comes to seeking a preliminary injunction, are really moot and unnecessary because you already have enjoined, meaning stopped, the Oregon law, the gun control law, in all relevant parts. As a consequence, there's nothing for the federal court to do right now in terms of enjoining the law because it's already enjoined, right? It's nothing for the federal court to add. It's already been done. So I think what's going to happen there is probably in those federal cases at some point in the future, there'll be some hearing or argument or decision, maybe on summary judgment, where they'll decide whether or not that law violates the Second Amendment's right to keep and bear arms. But for the moment, I'm guessing those federal cases are going to be put on hold in terms of going before the judge and having a hearing. They may do other things like engage in discovery or hearing, whatever. They may do other things to prepare the case for the ultimate trial on the merits or whatever they're going to do on the merits. But for now, I think the federal cases, for all intents and purposes, are going to be a sideshow because, again, the relevant gun control law in Oregon that was enacted in November has been enjoined and stopped, at least for the moment, by the Oregon court system, including effectively by the Oregon Supreme Court that refused to mandamus the decision of the lower court that enjoined these laws. And I think that was the right decision. So we'll keep you informed as to what all this means out there in Oregon. Obviously, this is a huge victory for our right to keep and bear arms. So I congratulate the plaintiffs out there in the state of Oregon, and you did a great job, and congratulations on your big victory, and we look forward to watching you from afar as you move forward. Okay, I hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.